Showtime, all right. Good afternoon, good morning, it's still morning. I'm sure everybody's psyched to be here. I know I am. I can report that it's still raining outside. So nobody's missing anything. There's nothing better to do than to sit here on a Sunday afternoon and listen to lawyers talk and talk and talk and talk and talk. All right, so I'm actually interested that this is such a diverse program. I mean, I think you just heard about matrimonial law, prenuptial agreements. I don't know anything about any of that. I do personal injury. I'm a trial attorney, and that's my specialty. But it must be interesting for you guys to sit here and listen to all these different topics. Everybody here's a lawyer, right? This is a CLE thing. No law students, right? These are lawyers. Okay. I've done a lot of these lectures, and what I really always stress is that I want people to ask me questions. It's much better if I know that I'm answering a question that you have, a concern or a topic, because I've sat in your seat and it's kind of boring when you're listening to somebody who's not talking about anything that you have an interest in. So please raise your hand, share an experience. How many people here have actually tried a case? Okay. And of the people who tried cases, how many tried jury trials? Okay, we got a few. So please, feel free to share your experiences. I got a lot, but I could always use some help from the audience. Just by way of background, you know, this light's crazy. I like to walk around, but I feel like there's a spotlight on my face. Okay. Just by way of background, like I said, I'm a trial attorney. I started out in the DA's office in the Bronx, which is, for anybody here who wants to really be a trial lawyer, the DA's office is the best training ground to learn how to try a case. It really is. They give you a lot of responsibility early on, and you'll never get that in private practice. Then I left the DA's office and did insurance defense work, representing insurance companies who got sued, and the firm I worked at specialized in medical malpractice, defending hospitals and doctors. So that became sort of a specialty of mine, and then I joined the firm I'm at now a long time ago, and I specialize in med mal on the plaintiff side. My firm does all kinds of cases, car accident cases, slip and falls, but I specialize in the medical malpractice cases. So for that reason, I'll probably be giving examples, I definitely will be giving examples that include personal injury and med mal cases, but this is going to really relate to every kind of case, every area. What kind of law do you guys practice? How many people, does anyone do personal injury or medical malpractice? The trial people? I guess matrimonial people are here because we just had prenuptials. Anybody do matrimonial? Okay. Just call out. What else do people do? Commercial litigation? What are the topics here? Go ahead. Immigration. This is a lively bunch here. Come on, guys. Corporate? Okay. So what are the afternoon topics? Are we like all over the map? I saw something about ethics. All right. All right. So where are we? Okay. We're going to be talking about trial preparation. I'm going to try and keep it general because we have a varied group here that has different areas of law. But, you know, if you do trial work, you can really try any kind of case. The thing about doing trial work is, you know, the rules of evidence are the same. But today we're not really talking about the actual trial. We're just talking about the preparation to get to the trial. That's where, you know, you need to know the specifics of the law that you're covering. So what we're going to talk about as far as preparation applies to everything, not just personal injury, medical malpractice. As far as general concepts about trial prep, it's similar to what I would say to people who are wanting to be trial lawyers. It's very specific to who you are. And when I talk about trials, I talk about being yourself and, you know, being true to yourself and who you are. Because there's a lot of different ways to try a case, depending on your personality and how people perceive you and how you perceive yourselves. But, and it applies to trial preparation too, because trial preparation can be a lot of different things. You want to prepare in a way that helps you best. Let's look at the slides here. Okay. Well, that's the general stuff. It's to be yourself, to have a personality. But so trial preparation always begins and ends with what people refer to as a trial notebook. Because when you're preparing for trial, you have to put stuff together somewhere. So everyone talks about a trial notebook. So what's a trial notebook? There are 100 definitions of a trial notebook. When I was in the DA's office, there wasn't much paperwork. You have a criminal case, you have an arrest report, a police officer, and a complaining witness who claims she was robbed. So you go to court with a piece of paper, a cop, and a witness. And you put on the witness, you say what happened, he put a gun to my head and took my money. You say to the cop, you say to the witness, who did it? He did. And then the cop comes on, that's the guy arrested. And it's pretty much over. So how do you prepare for that kind of trial? Well, the way I prepared for those trials is I would prepare a trial notebook of law. So I would put in a notebook the different areas of law that I expected to come up, all the different issues that I thought would come up. Things for, jury selection, opening statements. It's mostly evidence. So if there was something that I thought was going to be an evidentiary issue, that would go in my trial notebook. When I got to do civil law, and most people here are doing more civil kind of stuff, it became a paper parade, right? There's just thousands and thousands of pages of paper. Medical records that you could fill a room with. So the trial notebook became much, much more important when you're talking about a case that involves paperwork and that kind of documentary type evidence. You gotta keep it organized. So that became a much bigger task, and so the trial notebook really is where you start. And you think, okay, where am I going to go with this? What do I need to put in my trial notebook? How do I want to organize it? And that's what we're going to talk about today. But so we talked about, I mentioned your personality, okay? So I'm pretty neat. I want everything in order. Everything's going to be lined up. My notebooks have beautiful color-coordinated tabs, highlights, red, blue, green, all that stuff. And that's how I work. That's what works for me. And I think I have success with that because when I come into court with my notebook, it looks good. The jury is looking at me thinking, wow, this guy's got his stuff together. I open up my notebook, I got my tabs, looks like I'm prepared, looks like I know what I'm doing. And my desk is clean except for my notebook and my red welds, and it looks really good. And to me, impression is everything, especially when you're doing a jury trial, right? You want to impress the jury. You want them to think that you know what you're doing and that you're prepared, and that goes a long way when you're trying a case. So I have everything in the trial notebook. I'm going to get to the specifics. On the other hand, some people can't get their heads around things like that and can't put stuff together and aren't as organized. And to me, that creates a poor impression when you're in the courtroom and the papers are everywhere and you're trying to put a photograph in evidence and you can't find it, or something comes up about an argument you had during discovery and you start rifling through your stuff trying to find the correspondence. It's appearances that matter most, especially in jury trials. So overall, the notebook is very important. Okay. This is key to any kind of preparation for any case. So, how do you prepare for a trial? What's the first thing you do when you want to prepare for a trial? You have to sit down, either by yourself or with your partners, and the first thing you have to do is think of a theme of your case. What's going on? And I'm talking mostly about jury trials. What's my theme here? How am I going to make this presentation and win this case and win over these 6 people who I have no idea who they are, never met them before? How am I going to win them over? What's the simple theme of my case that I'm going to carry throughout every step of the way, from jury selection to opening to direct, cross, closing? What's my theme? That's the most important thing you got to develop early on, because that'll carry you all the way through. For example, we just finished a case where it was a products case where Wolfgang Puck's pressure cooker that you see on QVC or wherever wasn't made right. There was a device that's supposed to lock when the pressure is still in the cooker. And my client thought the food was done and went to open the cooker, which you shouldn't be able to open the cooker if there's still enough pressure there to cause some serious damage. And there was a little device that's supposed to be regulated by the amount of pressure in there. Turned out the device was like a piece of plastic that really wasn't too good. And when the guy pulled the cap, it exploded. And he suffered burn injuries, which was horrible. Actually, we deposed Wolfgang Puck, who had, for this very product, made an infomercial where he said that, I'm not going to do his accent, but where he said that the only way that you could hurt yourself using this pressure cooker is if you drop it on your foot. That was his pitch. Well, they settled the case, but we started the case, and we started the case with a theme and a theory, and it was, you know, products liability cases are pretty easy to come up with themes. It's all about money. The corporation, to save money, made a product, and the device that they should have made out of steel or whatever, they made out of plastic because it was going to make them more money. And because this big company and corporation wanted to save money, they put people's safety at risk. And that's the theme throughout. Okay, so with the theme set, then what's your next step? The first thing I say here, if you take nothing else away from this lecture, if you take nothing else, remember this, the PJI. Who knows what the PJI is? Go ahead. The pattern jury instructions. Okay, if you're going to try cases and you're on a budget and you don't want to attend lectures like this, you don't want to buy books about how to try cases, the only thing you have to get is the pattern jury instructions. What's in the pattern jury instructions? Does someone want to explain it, or should I do it? I'll do it. Okay, so the pattern jury instructions is so important, and you know what? It doesn't even apply just to trial lawyers, because anybody practicing any kind of law can benefit from having the PJI and utilizing the PJI at every step of the way. I use it, and I have my attorneys use it from the time you take in a case up, and it's about trials, but you need that book when you're preparing all throughout. The pattern jury instructions, okay, is the book that contains all the laws that are in effect in New York State, all of them. But it's a book that doesn't read like the CPLR, with the heretofore, henceforward, therefore, nothing like that. Because the pattern and jury instructions list all the laws in the statute, but it's written in a way for jurors to understand. Because the pattern jury instructions are what's read, the sections, the relevant sections in a trial, are what's read to the jury at the end of the case in the jury charge. That's the law. So, and it's got every case imaginable. It's more than one volume. It's kind of big, but you need to have it. You need to be familiar with it. And the beauty of it is it's written in English. English. So anybody could understand it, not lawyers, specifically not lawyers. And in the instruction, it's written so well and so nicely, it lays out everything you need to know to prove your case or to defend your case. So that's the kind of thing you need to know when you're considering, should I take this case? Whatever you do, immigration, matrimonial, personal injury, you find that statute that applies to your facts, and then rather than go to the CPLR and get through the henceforward, heretofore, therefores, you start reading English, and then you can see, hey, do I have a case or not? What's even better is that with each charge that's in that book, there's notes afterwards, commentary. And the commentary is beautiful because it's updated every year. And that commentary provides actual case law to support each statute that it's describing. So that's it. That's all you need to be ready to try a case and to present it to a jury. Because what is a trial? A trial, it's just a story. It's a movie. And you got to be entertaining. And it's a story that you're telling to 6 people or 12 people or whoever. And you want to convince them that what your version of the story is right. That's it. That's all it is. And so if you're going to be the writer, director, producer of this movie, okay, I don't know if anybody's written screenplays, a lot of lawyers have, but if you're going to do that here, then if we turn now to make this a screenwriting lecture, how do you write a screenplay? It's the same thing as how do you try a case. How do you write a screenplay? You start at the end. You got to know how it ends so everything you do during the movie makes sense. You got to know how the trial ends. You got to know what the jury's going to be read as far as the law. So this way, every step of the way, you know where you're heading and what you need to have in evidence, what you need to hear them hear in order to prepare properly. So it's sort of backwards, but it has to be, because the PJI doesn't get read. It's the last thing that happens in the trial, the very last thing, because after all the evidence and all that, the judge sits there and reads them the law. It's so important. I happen to think it's a little backwards. I think the jury should be read the PJI instructions before the trial starts. That sort of would make sense to me. Then they'd sort of know, okay, what's going to be important, because as it is now, they can hear everything, and even if it's not important, they're hearing it, and it's sort of affecting them, I would imagine. So anyway, that's my opinion, but that's not how it works. And what's even a little worse is they don't even get a copy of it, like written. It's like some of these charges could take 45 minutes, right? And they're being told how they're going to make this decision, and they're supposed to remember everything. So they're not given a copy of it. So the whole thing's still a cockamamie in my mind, but it's the system we have. So you need to utilize this PJI. And I know I'm spending a lot of time on this slide. I'm spending a lot of time on that first line. There's nothing more important today than that. Does anyone have a question? We're still good? Okay, because when I talk about a theme and all, the PJI, and this is again, a huge important point for any trial prep. The PJI gives you those words, right? The words, the narrative, the actual law. So that those words are going to be what you use in trial prep and jury selection and opening and cross-examination. What do I mean? If I had it in front of me, if you read the charge that's written and given to the jury on the emergency doctrine in personal injury law. So there's car accidents, right? And if somebody's sued because they caused the accident, a lot of times the defense is, hey, you can't blame me, it was an emergency. It was an emergency. The car crossed over the double yellow line. You know, you're not supposed to really anticipate that. That's crazy. That's an emergency, right? So that's a valid defense, right? But so you go to the charge. If you know you're trying that case on either side and that's going to be an issue, you go to that charge in the PJI and you read it. And when you read it, it says emergency doctrine. If in the face of an emergency and there's a sudden emergency and and then it's an emergency, it's an emergency. And there's a sudden stop, an emergency. 10 times the word emergency comes up. So if I'm defending that case, from the moment I start that jury selection and the people walk into that jury room and they're all just about as excited as you all are right now to hear me talk, the first thing I'm saying to these people is, that's an emergency. Yeah, that's an emergency. Every other word out of my mouth, emergency. Okay. And then my witnesses go up. What did it appear to you? It appeared like an emergency. It's an emergency. And then my opening statement, emergency. My closing statement, it's emergency. And then what happens? What happens is the very, very last thing, PJI, and the judges, 99% of the time, the judges read from the PJI, word for word, at the end of the trial. They open that same very book, and they word for word read that charge. Why? Anybody know why the judges word for word read the charge?
It can't be reversed on appeal.
There you go. He said because they can't be reversed on appeal. What's the worst thing that can happen to a judge? Not many things bad can happen to a judge. They're in charge, right? It's their courtroom. They can do whatever they want. The only thing they don't love is getting reversed on appeal. That's like, yeah. I mean, I read the law journal, I read the cases. If I see they're reversing it, what's the first thing I do? I go back to the top and say, what judge was this? So they hate it. And that's why they push to settle cases. This way, nothing gets published in the Law Journal. It's true. So one of the biggest, or probably the biggest area, one of the biggest areas of reversal rates come from charges that are improperly read to the jury. So it's a weird sort of case. Maybe it doesn't fit totally within the PJI, or the facts of a specific case have something a little funky going on, so the judge has to improvise a little bit, and they go beyond the wording in the PJI, and that's where it gets a little dicey. Okay, so that's the 1%. So the 99% is open the book and read that charge the way it appears in that PJI, because if that happens, he ain't getting reversed. She ain't getting reversed. Nobody's getting reversed if they read the PJI word for word. No criticism there. Again, that's underscores why is the PJI so important. That's what's coming in. And that emergency, when that judge, you know before the trial that at the end that judge is going to read that charge and say the word emergency 10 times. So what happens when the judge says the word emergency? The people in the jury box say, "Gee, that guy didn't shut up about emergency. All he was saying is emergency. So I must be right if I was saying emergency." Now, this is like psychological warfare going on, but that's what a trial is. I mean, yeah, question, thank you. What do you got?
Do you incorporate your PJI buzzwords during jury selection?
Yes, she asked if I incorporate my PJI buzzwords during jury selection. 100%. Now, this isn't about jury selection, this lecture.
Right.
I can give whole lectures on jury selection, but that is so important. Okay, because jury selection, I'll just go off on a little side. Jury selection is the first time that the jurors are hearing what your case is about. The first time. And there are studies done on what first impressions are. When I came in here and they said, "Oh, he's wearing a pink tie." Oh my God, the speaker's got a pink tie. Everybody formed an impression. He's wearing a suit on a Sunday and he chose a pink tie? His girlfriend must have chosen that. But whatever it is, you all formed an impression when I first started talking and thought, well, maybe this guy's full of crap, or he's funny, he could be interesting, whatever it is. There are studies done that first impressions are extremely, extremely meaningful. With that in mind, when you're going to pick a jury and you have a case that you've carried for 4 years and you have a family with their financial future resting in your hands, and it's finally time to put on the show and to have your day in court, these are the people who've never seen you before, who could care less, and now they're going to make this decision. So with that in mind, the first impression has to include what they're going to be asked to decide at the end of the trial. And not only that, it's you get it in, you get the buzzwords in wherever and whenever and however you can, whenever the jury's in the room. So it runs through your entire case. So it's jury selection, you have your witnesses prepared to talk that way, you cross-examine people, and all you're saying on cross-examination, wouldn't you agree this is an emergency? Whatever it is. And then your summation is all throughout. That's the most important thing that I could say today, is use the PJI buzzwords to prepare for trial. That's it. And it's not even just trial. Like, you prepare for a deposition that way, right? If you're going to depose somebody with the hopes that you're going to make a motion for summary judgment after the discovery's over, then that's the most important thing you could do at the deposition. Know the elements, know what you're going to put in that summary judgment motion, know the elements of the affidavit for your expert that's going to have to accompany that summary judgment motion. So the buzzwords are going to be in his or her, the expert's affidavit. So if you don't ask the questions at the deposition, and you got a really good case, if you didn't ask the questions, you could blow an opportunity to get summary judgment where you could either have the case completely dismissed, or now you got a judgment and interest starts running if you're the plaintiff. Okay, we good? Most important thing. I think I'm done. Actually, that was the most important thing. Just kidding. Okay. Oh, all right. So the last thing I'll say about this, the jury charge and the verdict sheet, again, that's the end of the story. So while you're doing the PJI and knowing the buzzwords, you really should also, to prepare for trial, know what sections of the jury of the PJI are relevant, so that goes without saying. But the verdict sheet too. The verdict sheet is a little tougher to predict because that is more discretionary. It depends on like what came out at the trial. You don't know what your adversary is going to be requesting as far as the verdict sheet goes, but you know what you're going to want to ask or request to be on the verdict sheet. And you get the idea how important that is, because whatever you've done for the last 4 or 5 years as you've carried the case, it all comes down to 3 questions, right, that the jury's going to answer. Was the plaintiff negligent? Was the defendant? Whatever it is. They could be pretty complicated, but they could be simple too. But those are the 3 questions at the end of 4 or 5 years of work that these strangers are going to be asked to consider. So think of it. Think of what you want those questions to be. Think of what most likely those questions will be. And that also is directing and dictating how you are preparing for trial. All towards those 3 questions that the jury's going to get. All that is hugely important. That's why I put it up here first. Okay, I'll move on. Anybody have a question about what we talked about so far? Okay. I talked about this. These are different notebooks. We talked about that. Okay, so when you're actually getting into the nitty-gritty of, okay, what do I put in my trial notebook and what's my theory? At least in my practice and in most of the practices that have been suggested here, the depositions are the most important part of your case. And I can't stress enough how important it is to be familiar with the depositions. There's no better ammunition for someone doing cross-examination than prior sworn testimony. And if there's prior sworn testimony on this specific case by a witness, that's the sole most important item in your arsenal that you have to know cold. So however you want to digest that, a lot of people do different things with depositions. One thing I don't suggest is to give it to a paralegal and say, hey, digest this. So instead of reading 150 pages, you get 3. Because it's single spaced and you put the page number and then the concept that was covered on that page. Don't do that. I mean, you could do that, but you still got to read the depositions. You still got to know what's on there. I mean, when I'm preparing to cross-examine somebody and I'm writing down my notes about cross-examination, I will have, I do it generally with topics, but with each topic that I'm covering on cross-examination, I will reference the transcript and the page number and the line number in my notes. So that looks really good. I'm not going to go through a whole cross-examination, but if you know off the top of your head an area where the witness is probably going to waver, or the crux of the case where you know they may not be entirely consistent with what their theory is, then that's gold, and there's a way to go through that. But you need to know the page and the line number, where you're going, because what's going to happen is you do the cross-examination, and while everyone's always excited when you hear an inconsistency and that you're going to be able to, impeach this person with prior sworn testimony, it's great. But the actual steps you have to take to get there, it's not like Law and Order, right? You actually have to build it up the right way and make it so that it's going to be smooth and the jury's going to be entertained that there's an aha moment coming up, So you got to think of all that. So there's a building block, step-by-step process you have to do to get to that point. But for today's purposes, just know where those inconsistencies may be exactly in that transcript. And by the way, I'll just say this too. It's all about appearances in a trial, because you just want the jury to think you know what you're doing. You want the jury to think you're winning. And, it's about bad things happening and you're just like, making believe that nothing bad's going on. I forgot what I was going to say. All right. Anyway, so just those depositions are hugely important. Know them and have them in your notebook. This is what I was going to say. If you are going to be using a transcript, and most of the time you will, the preparation is to, of course, do what I said and outline everything. The other preparation is all about appearances, as I was saying. So what you do is, if you're on trial and you know you're going to be using a transcript to impeach somebody, right before that witness comes up on the stand, during the break before that witness gets on the stand, you have a copy of the deposition and you give it to the court officer or the law assistant, whoever's in there, and you tell them, please leave this on the judge's bench for his or her convenience. Because what I was just talking about, the script moving and everybody, and you know, it's all working for you. What happens in reality is if you forget to do that, and you say, the person says the light was green, and in the deposition they said the light was red. And then you say, you testified on direct that the light was green, correct? Yes. Have you ever spoken to an attorney about this before? In fact, weren't you deposed before? And in that deposition, you had your lawyer with you, correct? You swore to tell the truth, didn't you? Yes. And when you asked on page 17, line 3, what color was the light? And did you say it was green? And then the judge is like, and you're ready? And the judge says, I don't have a copy. What are you talking about? Oh, and all of a sudden the sails go down and the wind is gone. So you have to anticipate these little things that happen. The last thing you want to do is leave the judge out of it. Because the judge is always like, what about me? I don't have any of that. Because you think, oh, I'm going to put this evidence in. I'm going to show the witness. I'm going to show the jury. Boom. Lights, camera. The judge always has to have everything that you're doing. So again, trial preparation. What are you preparing? You're preparing for a movie. So you got to have all your props. You got to have the set. You got to have the lighting. But you got to have the stuff. And you got to anticipate what the judge, most importantly, what the judge is going to be saying and doing. So what I do, and we're going a little out of order here, but what I do, there's something called the marked pleadings. Does anybody know what the marked pleadings are? Marked pleadings. So usually a judge requires, before a trial starts, what happens is you pick a jury, you get assigned a judge, and you walk in, and you don't see the judge, you see the law assistant, and the law assistant always says, who's the plaintiff? I'm the plaintiff. They say, do you have your marked pleadings? Huh? Right? And said, marked pleadings. So what are the marked pleadings? The marked pleadings, it's a copy of the summons and complaint, and it's marked, so they don't have to look at the answer. So next to every paragraph it says deny or admit to see what's, so you only have to look at one document to see if anything was admitted in the pleadings, which actually is very important when it comes down to the trial. So it's generally the summons and complaint that's marked and a bill of particulars that goes into some more detail about the case because, let's face it, the judge getting the case 99 times out of 100 never knew this case. We don't have a system where it stays with the same judge from the beginning. It gets bounced around all over the place. So the judge assigned the trial is learning about it the first day that you show up. So they need something to give them an idea what this case is about. So you give them the marked pleading. So that's generally what the marked pleading is. What I do is I anticipate trial preparation. I'm always thinking about what's going to happen. And I always think, okay, well, what during this trial is the judge going to need? Am I going to have pictures that I'm going to put in evidence? If yes, I'm putting them in that little nice marked pleading booklet that I'm giving to the judge. It's a bound thing or it's in a binder with a table of contents and tabs. And if a police report is going to be in evidence, I put that in the marked pleadings. I put it in the table of contents. And whatever it is, I have the binder. And before the trial even starts, I give it to the judge. So this way, when the judge says, where's the police report? I don't have a copy of the police report. Right? I said, Judge, it's in the marked pleadings binder. It's section 3, the green tab. Right? So that's trial preparation to get to that level. And then the jury's like, oh, the green tab. Judge, you didn't see the green tab? Right? Now I'm the hero, right? Everything's moving smooth. Because if what happens is they say, where's my police report? And I say, oh, I got to run to my red well. The papers are flying. Now the jury's like, oh, here we go. We're going to take a 10-minute break now for this guy to find the frickin' incident report, whatever. But this is real. It may be funny, but it's actually real what happens. So that's trial prep, is anticipating that kind of stuff so the movie and the play just run smoothly in your favor. Okay. Okay. This is very, very important. God, the time is moving quick. I'm not going to get to everything. But everybody with me, does anyone have a specific question about trial prep that they're dying to ask? I'm shocked. Okay. All right. This is hugely important because for every trial, or not, well, most trials, require documents to be delivered to the court. And most specifically in my field, it's medical records. medical records and medical bills and all this stuff, in order for them to come into evidence, they have to be certified. And we're going to get into that too. That's important too. And so in order to get something to the courthouse, you need a subpoena, okay? So a big part of trial prep is thinking, okay, because if you show up at the medical records and you show them to a witness, you can't just throw paper around in a trial, okay? It has to be certified. It has to be, it's hearsay. Whatever's in there is hearsay. So in order to avoid that, or in order to compensate for that, you have to bring in the maker of the record, who's going to testify that these records are kept in the ordinary course of business, and so you have to call somebody from the hospital, and this doesn't happen, right? The reason why it doesn't happen is because the court allows certified hospital medical records to just come into evidence, so long as the proper certification is on it, right? Terrific. So what do? You're supposed to, you have to, subpoena the records from the provider to go directly to the court, because this is evidence, right? We're talking chain of custody. I can't bring in and say, hey, here we go. These are the certified records. Doesn't work that way. It has to come from the place to the court with the proper certification. Makes sense. Pain in the neck, though. Real pain in the neck. Because I'll tell my staff, okay, for the Smith case, we need medical records from Dr. Smith, Dr. Jones, and whoever. So send subpoenas out to those guys and to Southside Hospital, and get those records to court. And they get this, you send a subpoena, and the lawyer's allowed to sign the subpoena. There are some where you have to get a judge to sign it too, but let's forget that for the moment. But you could have a subpoena, lawyer signs it, send it to the place. They're supposed to comply with the subpoena, right? So what does my paralegal do? He or she writes the subpoena, sends it out, and just patting himself on the back. I did it. I sent out the subpoena. We're covered. Are we covered? We ain't covered. We're only covered when we know that the records made it to the courthouse. Because what happens is, if I don't check that, and I show up to try my case, and they say, oh, you're going up to Judge Jones, and I say, oh, could you bring the subpoenaed records up from the subpoenaed records room? Because we're going to need those. And they come back and they say, there's no records in the subpoenaed records room. Okay, all right. My jury's picked. I'm starting opening in the afternoon, and my evidence didn't make it. Oh well. That's when panic sets in. You're paying private investigators to run to the doctor's office and get the thing signed, and you're okay. So, trial preparation. How do you avoid this? I'll tell you. This is not lawyer stuff. This is just common sense, hard-working anticipation stuff. What you have to do, if you know your case is starting on April 2nd, okay, you have to make it your business to get to that courthouse. Either you or someone from your office has to get to the courthouse to make sure that your records got there. Has anybody ever gone to a subpoenaed record room in Manhattan or Brooklyn or Queens? How was your experience, sir?
It's annoying.
It's annoying. That's one way to describe it. Okay, I'll describe my experience. The records room, say in Manhattan, you walk into a beautiful courthouse, you walk up the steps, the pillars, it looks beautiful. And you say, where's the subpoenaed records room? It's always in the basement. In the basement! I've got to go to the basement. So you go, and the steps in the 62nd Street, you're going this way, then this way, and it gets more narrow as you go down. And so you get to the subpoenaed records room, and it's a door, it opens up, and there's somebody who's just shocked that anybody actually walked in, who wakes up when you walk in. And there's just files and files behind this person. And you say, I'm an attorney. And they say, what? Congratulations. I say, I need to check the records on the case, the Smith case. And so what does he do? Now they have computers, so he looks it up. He goes, up, they're here. Is that good enough? No. Because if I sent a paralegal to do it, they'd say, oh, could you print out that sheet that says everything that's here? Sure. Here's a sheet. These records are here. And the paralegal comes back to my office. All the records are there. I say, did you look at them? No, that's why you don't send the paralegal. That's why you have to go, because what happens is you have to say to the guy, can I see them? Okay, that means he's got to get up, and the whole time he's doing, he's just looking at you. You got to get up and he's got to find those records that are in a box somewhere. And you say, he's like, I'm going to have to look for these. And what do you say? I'll wait. And then you sit down because you're going to wait. But then when he does come back out and he has the records, you say, well, now I need to look at them. Now, the rules are that you're really not supposed to take those records out of the room. Why? Because they are now certified and they're evidence, you know. So you would think the courts would sort of know this, but the room that you're in is maybe this big, and there's a chair, you know, with a wall, and you have to sit there. And so you have to put those records on that little table, and you have to open up the envelopes, and you have to look through those records to make sure that those are the records that you're going to need for your case, because it could be, and I can tell you this has happened to me, for Mary Smith, my client, who went to that doctor who needed, you know, we're going to trial. She had seen that doctor for many years. They sent most of the records, but not the ones that were relevant to my case, right? The other thing that's happened to me more than once is that the records that I got from a Dr. Jones read, you know, a certain way, and I had in my file for some time. Then when I went to the subpoenaed records room, turns out the copies that I had were one-sided, but the copies they sent to the court happened to be two-sided. So I had been missing half the records the whole time. I didn't know, but because I went to the records room a couple months before, I was able to see that. These are true stories. This actually happens. It's also just as important for films, and I'm going to get to that. I'm really running out of time here. I'm going to get to the films because the films have to get there too. In a lot of my cases, films are the most important piece of evidence. So if I'm proving that someone does not suffer you know, a soft tissue injury and they have a herniation that shows up on an MRI film, and that's the whole issue in the case, I need to get that film into evidence. And there's a better way to do it, and I'm going to go over that in a second. But that's my little spiel on the records room. I can't stress enough how important it is to make sure, and now they even have it, it has improved. I mean, my stories are from a long time ago. I think the records room are a little nicer and whatnot, but it's improved to the point where you can in most counties, and every county is like another country, right, with their rules and what happens and the procedures. But you can in most counties now go onto a computer and get that information about what's in the records room in the computer. So it's something, but you can't trust it because it's the same thing as the guy printing it out when you go there. You have to go there, you have to look at them. And I don't know how it is now, but it used to be that you couldn't copy them unless they had a copy machine in there. So I had to go there with like 2 pockets full of quarters because they don't have any change, they didn't have a card or whatever. I'm sure that's changed. But that's what that's about. That's very, very important. Okay, I think I know the next slide because this is really important. You could write these down. I think I put them in my written materials. Using these statutes will allow you, in preparing for trial, it will allow you to better prepare for the trial because these statutes are, let's say shortcuts for lack of a better word, but these are things you could use to get stuff into evidence without having to go through this subpoenaed records room dance, right? So if you are planning ahead and you comply with these, and I'm going to go through each of them because it's important, you will be able to have the most important documents ready to be put into evidence or agreed upon before trial. So there is no problem about getting these things into evidence because they're so important. Now, 4532A, I'm not making this up, that's the statute. And that's for MRI films. And there's a lot of case law on this because there's a lot of motor vehicle cases that involve this type of evidence. So they made this to make it easier for you to get these films into evidence. I'm not going to go through all of it, but essentially what you have to do is you have to get the radiologist who actually read the study, and the name's on the report. And this is hard, but it's not as hard as getting to that subpoenaed records room a month before trial, because you could do this whenever you want. You get that radiologist to sign an affidavit, and the statute has what's spelled out, what you need in that affidavit to say, hey, this is, I did this film, I took the film, I interpreted the film, the report is mine, and it's all cool. And the numbers that are in the affidavit match the numbers that appear on the MRI report, the actual film itself. So this way, you don't need to subpoena the records, you don't need to call that radiologist as a witness, And if your adversary doesn't object, it's got to be done 10 days before trial. So they realize that everybody who does trial work is a little stressed and always waits for the last minute, which you shouldn't do. But so as long as it's 10 days, it's exchanged 10 days before trial, it's good to go. But you want to do it way before 10 days before trial. So that's an extremely useful tool. And it's not just for MRI films. Whatever law you do, if there's stuff similar to it, you can handle it that way too. The next one is 3122A. That's specifically for medical records. So this whole song and dance about getting certified records, if you actually get them certified and you exchange it with your adversary beforehand and your adversary doesn't object. I mean, all these things, if your adversary objects, if you don't like this, or if they don't like it, you still are going to have to litigate it. It's going to be something to discuss at trial. But if you do it this way, it usually works. You might as well try. So if you exchange a certified copy of the records that you anticipate to be putting into evidence, that step by step, that'll tell you how to do it, and you're good to go. And the last statute is 3123, which is a very useful tool. This is a notice to admit. So what this is, and the statute goes step by step again, this is for any kind of trial, for any kind of issue, okay? If it's something that you think is going to be disputed and you don't want to have to dispute it, well, I shouldn't say that. If it's something that you think is so obvious that it should just be admitted, what you can do during the course of discovery is and you can do this at any time, you send a notice to admit to your adversary saying that, hey, your guy, even though you denied this in your answer, okay, we did discovery, and now I know that your guy was the owner of that car involved in the accident. That's a very important thing in motor vehicle law. And sometimes people who are opposing or defending those cases put in an answer, deny everything. Not his car, he wasn't driving, he wasn't there, he was watching TV, whatever. But then you go through the depositions, but it's still not pled properly. It's still not admitted, is what I should say. And if it's something that's so obvious that you want it to be admitted, so at trial you don't have to worry for them to at the end say, hey, he didn't own the car, where's the owner? Which would be a big deal because then you don't have a party that should be in the case, could be a nightmare. So that's just one example of how you could use the notice to admit. You could even try getting business records in that way. You can do a notice to admit that this contract is a business record. And that'd be huge. If you go into trial and the contract is at issue, you don't have to worry about, who wrote the freaking contract and how am I going to get this in evidence? The contract is a business record. There's no dispute. So this is a very, very useful tool to put your mind at ease and to keep you focused on what you need to be focused on, not like the side nonsense that always drives me nuts. Like, oh my God, what if this is going to happen? Okay, this can put a lot of things to bed. Another question. You get a gold star.
Yeah, thanks. Do you do this along with subpoenaing the records? Because like you said, if they object, aren't you kind of screwed if there's some, for whatever reason, it can't come in through these CLE sections?
Yes. The question was, do I do these things as well as subpoenaing the records to the courthouse? And the answer is yes, you absolutely do. But you're not as crazy about it if you do them both. And if you do it, let's say 6 months before the trial, and they haven't objected, okay, they'll have much less of a chance of being successful. And say, God forbid, the records don't make it to the subpoenaed records room, you didn't check. If you've done it 6 months in advance and they didn't object, the judge is going to say, well, what were you doing the last 6 months? Of course these are coming in. You should have you didn't object timely. And there are provisions in these statutes about objecting. Now, there are certain things, like if it's the crux of the case that you're asking them to admit and they ignore it, you don't win, right? It's still going to be something that the judge is going to say, well, we're still going to decide this case on its merits, right? Most of the time, if the defendants are awake or whoever is getting the notice to admit is awake, they will put in a response. There's only like 30 days you have to respond until things are deemed admitted. That's how the statute reads. But the reality is, if it's a issue that's the case is about, it's not gonna happen. These are really for peripheral issues that really shouldn't be being argued over. That's why they put these statutes in there for convenience, so the court doesn't have to hear nonsensical arguments that don't really relate to the case. But of course, to answer your question, yes, that's trial prep. Do all the steps. Okay. Any other questions? Okay. Okay. We talked about this a little bit. For the opening statements, what I said about the buzzwords is really what's most important. And I'm probably not going to get to closing. It's not that big a deal. But I'm always of the opinion that opening statements are so much more important than closing statements. And it goes back to the research I've seen and the knowledge that first impression is everything. And think about it. If you've tried cases, you know that you have a process. You get selected to pick a jury, you have to go to a room, you have to talk to the jurors, and the rules are really in jury selection that you're not supposed to be talking about the case, right? You're just supposed to find a fair and impartial jury. You're not a witness, you're not a litigant, so you really are not in a position to start testifying to the jury panel about what happened. Of course, that's all I do until someone objects, but I'm not supposed to. So you're really only supposed to be talking about, yeah, can you be fair? Do you have any, biases and all this other stuff? So if it's judge supervised, and I do that because civil cases are not supervised by a judge for the most part, unless there's some unusual circumstance. Criminal cases, you can't do that. There's a judge in there and it's all being taken down. So that's real formal. Civil cases, it's essentially a free-for-all where you get put in a room with your adversary and they say, hey, come back with a jury. I say, okay, nobody's watching. So everybody tries to get away with as much as they can. But the reality is you're not supposed to start talking about it until when? Until the opening statement, right? So this is, the jury has an impression of you and whether or not you're drone on and you're boring or they think he's kind of funny, they like him or whatever. But whatever it is, that opening statement, that first time they say plaintiff open or that's the first time the jury is hearing the facts of the case, the theory of the case, the meat of the case. This is the story. You know, in a movie, the first 10 minutes where they're going through all kinds of stuff, all of a sudden you know stuff that happened to these characters for the last 50 years because it's showing whatever it is. That's like a thing in movies is in the first 10 minutes, all of a sudden you know everything. That's the opening statement. So it's so important to prepare for that opening statement, to use the buzzwords because you don't get that back. We're probably not going to get to it because time is flying, but my opinion, summation, by the time you get to summation, you put in all the evidence, you come to court 3, 4, 5 days a week or 2, whatever, all the evidence is said, the jury has heard everything. What are you going to do? You get up and you tell the jury what they just heard, right? You're going to remind them that this is what this person said and you're going to remind them of their theory. I mean, yes, that's what closing statements are and they can be powerful and Hollywood likes them. Law and Order, they're terrific. But the reality is, I think by the time you get there, the jury has pretty much made up its mind. If you're going to sway somebody's opinion, and again, this isn't a whole psychological thing, because I really believe that people come in with preconceived biases and notions that it's really hard to change their minds about anything, in 3 days, right? But if you're it's gonna be real early on. And that's why jury selection, buzzwords, opening statement, those buzzwords, because if you have the chance, that's when it is. So yes. That's what I have up here about openings. That's why I think it's more important than closings, but by closing, I think it's over. Okay, and I will not get into this. So as far as trial preparation goes, there's so much that you can do on your own to prepare, to feel good, to get your stuff together and all that, but just as, if not more important, is preparing your witnesses, right? Because your witnesses are the ones who are telling the story. So this is obviously a case-by-case thing. Do I have a good witness? Do I have a happy witness, a bad witness? You have to evaluate it, and you have to adapt to whatever it calls for. I'll talk about lay witnesses in a minute. More importantly, I want to just stress that expert witnesses, and whatever field of law you have or you're in, there are expert witnesses. Okay, so and a lot of these expert witnesses testify a lot, right? There's a lot of transcripts out there on them. And you should know what transcripts exist for your witnesses. And the experts who go to court a lot, they like to think they are lawyers. They like to think that they know more than the lawyers who are questioning them. And oftentimes they're very, very experienced. And they do have more experience than the lawyer who's trying the case, more often than not. They've been in more courtrooms than the lawyers combined, usually. Some of these experts anyway. But my point is, no matter what their experience is, this case is different. Every case is different. Every case has something unique about it. And you have to prepare your expert witnesses. You can't let them say what they want to say. I'll meet you 10 minutes before the morning session. We'll just talk outside. We'll clear it all up and we'll be good. No. You have to, designate time to meet with them beforehand. The reality is, part of your trial prep and part of your theory should really include your experts. They should be the one, especially if it's a technical case. I'm talking about a pressure cooker. What the hell do I know about pressure cookers, right? I went to law school. So I needed an expert who taught me about pressure cookers and how they work and the whole physics and science behind it, right? And I talked to the expert before I did the depositions. I sounded like a pressure cooker expert. 2 days later, I forgot everything about pressure cookers. But that's the nature of what I do, right? One day I'm a pathologist, one day I'm an orthopedist, and then I'm a pressure cooker specialist. But so that's because I rely on my experts. So trial prep, you have to use your experts. Now, it gets expensive, right? Because they're not just showing up because they like you, right? You got to pay them. So this is where, trial work is a business like anything else. And you got to decide what you want to spend money on, what you can, and what you can't, what you should, what you shouldn't. So I'm just telling you the right way to do it, the best way to do it, is to get those experts involved from the beginning, keep them involved, and when it comes time for trial, you got to prepare them. You got to prepare them with, okay, this has been the testimony so far. They have to know what the witnesses have said so far. That's why you have to get the transcripts, which also costs money. But whatever, we're digressing here. The point is, meet with them. Now, as far as your clients are not professional witnesses. Your clients are just people who happen to be involved in a lawsuit. So you have to figure out what's best for that witness. So there's some witnesses that could be terrific. My approach on a direct examination, if I have a great witness, I try and hide. I want that, that's the only time where at a trial, I'm not the star of the show. I always want to be the star of the show. Everybody's looking at me. I'm jumping around. I'm making jokes. I'm being funny. But if my witness is the one who's injured and she has to be the one that's going to sway the jury and garner sympathy, which they're not supposed to, but of course they do. If that's the case, I position myself, if say the witness is shy and doesn't like speaking in front of people, which is most people, if this is the jury box over here, I'll position myself right behind the jurors to force my witness to look at me, which makes it look like she's looking at the jury. And I'll just keep moving over like this until she is looking at the jury, okay? And of course, I want her to tell the story, not me. So there are times where if they're going off, I'll just sit down because I don't want the people to be looking at me. I want them to look at her if she's a great witness. On the other hand, what if you got a lousy witness? What if you got somebody who is not nice and people would not like them? What do you do? Any suggestions? Do we give up? No. So what I do, and this goes for any kind of case, but at any stage of the case, you can't change your witnesses. You can't change your clients. And if you have a bad client, just like if you have a bad fact, something bad, there's an alcohol level that's in the blood, or there's something in the guy's background, he was arrested, okay? You have to deal with it, okay? And part of trial prep is dealing with bad facts as much as it is dealing with good facts. And you deal with it right away, right in jury selection, right? If your person, and here's a big tip. Don't ever assume that your adversary doesn't know that the guy has a record. Don't ever assume that your adversary doesn't know that he was in a car accident 2 years before. They didn't ask about it at the deposition, so maybe they don't know. Let's hope they don't know. Let's hope they don't know. Let's hope they don't. No. They know. Believe me, they know everything. Because even though the guy asking the questions at the deposition didn't know, the guy trying the case knows. They know. You got to assume they know, right? So you got to deal with it. And, you just say it. You just say, you're going to hear this. In jury selection, and you ask them, if you hear this, is that going to affect your ability to be fair? And then when the person's testifying, he is who he is, or she is who she is. I mean, there was one time I had a horrible client, and so what time is my thing over here? Okay, so we're good. So I had a client who was terribly hurt. I mean, it was a great case, a construction site case where he fell off a ladder, which is, if people who don't know, that area of law is very pro-plaintiff. You fall off a ladder because the ladder shifted or the collapsed, whatever, you win, right? So we had summary judgment years ago. Interest is running for 2-3 years, and now we're just trying damages, right? We're just trying how badly was he hurt, and the guy was hurt really bad. Right? I mean, he fell 2 stories down a ladder. He really was banged up bad. Permanent injuries and whatnot. Problem was, the guy was just hateable. Pure hate. Like, everybody in his life hated him. His wife, his kids. I mean, if you sat in a room and you had a 2-minute conversation, you'd say, oh, who is this guy? I mean, nasty and sour and just a bad, bad guy. That's who he was. And so we're thinking, oh my God, we got this case. We're going to be asking for millions of dollars for this guy, but they're going to hate him. He's a terrible guy. Who's going to give this guy any money, right? So how do you handle that? Trial preparation, what are we going to do? So, by the way, does anyone notice I keep saying trial preparation, right? Because I want to make this, I want to tie it into the course, right? So subliminally, everyone thinks that all I talked about today was trial preparation. I really haven't. I'm telling you how to try a case, but I keep saying trial preparation because that's what you paid for. All right, whatever. So that's it works. So what do we do about this guy who everyone's going to hate? We know everyone's going to hate him. I went in jury selection. I said, hey, we got a great case. Guy fell, whatever. I said, I'm going to tell you something now. You're going to meet this guy. He's going to testify. And I'm telling you all right now, all of you sitting here, you all are going to hate him. You're going to hate him. And everyone's like, oh, that was a joke. And they started laughing, just like you did. I said, no, I'm not joking. You're going to hate him. Everybody hates him. Everybody he comes across hates him. And everyone's like, really? And I said it got some laughter. Whatever it is, I now deflated any kind of advantage the other side thought they'd have in their trial preparation, thinking, oh, no jury's going to give this guy $7 million. They're going to hate him. But I already told them they're going to hate him. So that's sort of gone already. So now they're going to more listen to what happened to him and how injured he is, rather than like, wow, he's nasty. He's a nasty guy, right? That's off the table. We already knew that, right? So that's how you prepare, trial prep, to deal with bad facts. Oh, that's not on here. It's on a different slide. Okay, let's see where we are. We'll talk about that. We talked about that. I don't want to talk about that. This is important as far as trial preparation. There are so many ways now with the internet and all this stuff to get dirt on people, specifically on experts. And this is hugely important. It's a huge part of trial preparation. It's a part of deposition preparation, really. But with professional experts being used more and more, everything's specialized, and with these kinds of experts available, used on every case, and the internet being as open as it is, you can, and there are all kinds of services. Plaintiffs have listservs and these sharing, these chat rooms, these blogs or whatever. I get transcripts now from California, from every state in the union. It's very easy. What you have to do is if there's ever, and even if it's a lay witness, give it a shot. Google the person, put it into these search engines to see if there's any transcript on these people. But for medical witnesses or experts specifically, there's no better tool or piece of your arsenal than a prior sworn testimony, whether it's a deposition or a trial transcript. And they're out there, and these days you can get them. And if you don't get them, then shame on you. Because even if it has nothing to do with your case, if there's an expert who testified anywhere on anything, you got to get it. Why? There's got to be something in there that you could use. Got to be. Because every expert who's on the stand has to go through his credentials. Every expert that's on the stand has to go through his or her experience. Every expert on the stand is, there's always some sort of what we call collateral attacks. A collateral attack is an attack on an expert that has nothing to do with the case that you're talking about. It's about his qualifications, about his bias, about his only testifying for plaintiffs for 30 years. He's not once testified for a defendant. So you're painting a picture of a hired gun, right? I mean, I would come in, if I knew a defense expert only testified for defendants. I mean, there were times I put on the table, when the witness gets on, boom, transcripts, a whole bunch of them. And nobody knows what it is, but the expert knows what it is, because the expert's been cross-examined, but the expert knows exactly what it is. And the expert is so, and if the expert's not sure, and I start doing a collateral attack, and I say, is this the first time you've tested? This isn't the first time, doctor, you've testified, right? Oh, no, I've testified. And in fact, you've testified 100 times last year, isn't that correct? I'm not sure. So I go to the middle. I don't know where I'm going. I go to the middle. And I'm going, I say, are you sure it wasn't 97? And so the doctor said, oh, if I said 97 before, then it's 97. Because they don't want me to start reading about this in front of the jury. So now the expert knows that this is a list of transcripts. So then every time we got into a little tiff, I would just walk over, put my hand on, you remember? Yeah. Oh, that's the time. Yeah. Right? So, but this, now, I will admit that I've had situations where not every one of those transcripts really did relate to that witness, but it looks good. And I know that the witness testified 100 times. Maybe I didn't get all 100 transcripts, maybe I got a couple, so I threw a couple extra in there, just to make it look good. But the truth is, if you can get the testimony, you have to get it. So trial prep, resources, internet, all these listservs, whatever you got to do to get in that group of people that, and it's a transcript sharing bonanza, because everybody knows how valuable those transcripts are. And so here, again, trial prep, not just the ones you're going to be cross-examining, you need to get your experts' transcripts. Okay, I now have on PDF in files in my computer lists of lots of transcripts from my experts that I'm familiar with, that I remind my expert, hey, they're going to have all these, because if I got them, they got them. So we talk about it and we prepare, okay? But those transcripts, and then, you know, even out there, because the courts are more accessible and motions are more accessible, I get affidavits from these experts that were submitted in support of a summary judgment motion. So that's not as good because it's not really a sworn statement, but it's notarized and he's affirming or whatever. So anything you can get with that expert's name on it is valuable, so get it. That's what this is here. I mean, going to the scene is obviously without question. You know, for any case that involves an accident, you have to go to the actual scene. Okay. All right, so again, trial prep is thinking about how you're going to tell the story. And at some point, and a lot of you now are starting to yawn, I've been up here, I know my shtick, I'm going to do a little dance. Okay, so what's better than hearing me talk? I got a picture. I got an animation of the cars, and an explosion, right? People are used to now sound bites. It's like 2 minutes. What is it, a GIF? Well, how do you pronounce that anyway? GIF or GIF? I don't even know. Do you know what I'm talking about on Facebook? Okay, whatever. So, but that's what people are expected. 3 seconds. 3 seconds, come on, move on. Like 2 seconds, 10 seconds, come on, move. So for your trials, you have to prepare, what are they, a dog and pony show or whatever the phrase is. You have to be prepared to keep them engaged as much as possible. Now, of course, there's limits. You're in a courtroom. But so what you want to do is you want to think before the trial, when you're doing trial prep, what can I do? What charts can I blow up? So I have medical malpractice cases with thousands and thousands of pages of medical documents. And no matter how many pages there are, in almost every case, 4 pages matter. I got to tell you, for the most part. The 4 pages, I find them, that's it. That's the crux of my case. That's the theory of my case. So what do I do with those 4 pages? You know, and there's a lot of options you have these days. It used to be just, you know, Kinko's. But you blow them up to the size of the door, right? And you put them up. Now, let me say this. Okay, I only got 4 minutes now, but let me say this. Trial work is still in the Stone Ages, okay? Because, not federal court. State court is in the Stone Ages because everybody here has a laptop in front of them. I see all these apples, I'm getting hungry. But everything's online, everything's this and that. And you could do a beautiful PowerPoint or a beautiful whatever for a trial, and that would be great. The problem is, and I'm telling you now, it's still a problem. The courtrooms that you're trying cases in the 5 boroughs are not equipped to handle technology yet. It just hasn't happened. Each borough has maybe one court that they call the courtroom of the future, right? And they got a big TV, right? So the one that's for medical malpractice cases actually has a huge overhead, which actually works because they have 6 screens in the jury box, a big screen behind the witness, a big screen behind me, and I just put it on it's like, you know, when I was in 3rd grade, the transparency thing, you put it down, and oh, there it is. But it works because it just blows everything up. So that's the courtroom of the future in Manhattan, okay? So what happens is if you're going to bring your laptop and you're going to have a whole thing on a big screen, that you have to bring the screen. There ain't no screen in the courtroom. You know, you got to think of all this stuff like you're doing a production here. And then what happens is you get to the court, you got all this stuff, and you got your assistant and all this stuff, and then all of a sudden you're like, where's the outlet? There's no outlet. Or the outlet's over there. Where's the extension cord? I didn't bring an extension. You have an extension cord? Go buy an extension cord. I mean, and I'm not exaggerating. This happens over and over. When this all first started, I had a projector, you know, with this. It would go to sleep, and then I needed it. And then and then I'd start up again. I was like, oh, and everybody in the courtroom was like, oh, the projector's whirring, it's going up. So my point is, you can't rely yet on technology in the courtroom. It sounds great. I still, to this day, use blow-ups because I could pick them up. I could hold them. I could show them, put them down, pick them up, put them down, pick them up. Here, you know, no good. So, blow up what you can. Pictures, especially, jurors love pictures. Listen, if you can work out an animation of a reenactment of something, that's terrific. But you have to, if you're going to do that, you have to know what court you're going to. So this works in federal court because the dates and the judges in federal court say, we're having a trial on April 2nd. Guess what? On April 2nd, we're having the trial. In Supreme Court, New York, or any other 5 boroughs, we'll see what happens on April 2nd. And then come back in May, we'll see what happens. I have another, okay. I'm not even kidding. That's how it goes. So you can't do that. You don't, and you don't know what judge you're going to get. You don't know what courtroom you're going to be in. You don't know anything. Okay. So very, very important to think about what you want to blow up. And it works too with witnesses. When I say repetition works, I got 2 minutes. When I say repetition works, if you have a car accident, I'll use that example, and you have the witness describe the accident. And she says, well, I got out of my driveway, I made a left on Main Street, made a right on First Street, and at the intersection of First and Second, I got into the accident, and the guy was going fast, and we hit each other, blah, blah, blah. And so they hear the version of your witness. And you say, oh, take a look at this. Does this fairly, and you have a blow-up at the intersection. And you say, does this fairly and accurately show the intersection where the accident happened? Does it fairly and accurately show the streets that you went down before the accident? Yes. I asked that it moved into evidence, granted. Now it's in evidence. So now, I take it, I say to the witness, show me on here how that accident happened. Well, I got up, and now she's pointing to the thing, so now she's giving a second version of the same exact testimony for the jurors to hear again, so it's repetition, but now they're looking at a picture. So they had an image, now they're looking at a picture, it's repeating, now it sticks, that's effective. That's effective stuff. You know, I got a minute, so are there any questions that I can answer in a minute that anybody has? Yes?
What's your biggest challenge in the courtroom?
Any other questions? No. He asked me what the biggest challenge in the courtroom is. For me, and this is my little Michigas craziness, I'm always worried about what's going to happen next. That's what drives me crazy. That's why I prepare so well, is because I prepare for every possible possibility, which is effectively and literally impossible to do. But that's why I don't sleep, that's why I have a bad stomach during a trial, because I'm always trying to anticipate everything. So my challenge is to relax. To relax and just trust in my theories, trust in my ability, because it's all on your feet. You can't predict everything. So I'm always telling myself, well, listen, you've tried 100 cases. There's nothing I haven't seen. Then I'm like, maybe there is something I haven't seen, you know? So it's really just relax, stay confident, stay calm, and be myself, because it's worked so far, so it's going to continue to work. Anything else? Okay. Thank you all so much.